How does California Probate Court drain your estate? Today we're tackling an important topic that affects many families across California, the cost of probate. Whether you're dealing with the recent loss of a loved one or planning for the future, understanding probate and its associated costs can help you make more informed decisions during a challenging time. Probate is generally required if the deceased owned assets solely in their name, or if there isn't a clear beneficiary designated on the account. However, some assets that are held jointly or have designated beneficiaries, like life insurance policies or retirement accounts, can bypass probate entirely. Today we're focusing on the probate process and, more importantly, the costs involved in that process. Now you might be wondering, why does probate even cost money? The probate process involves a number of administrative tasks and legal formalities that require time, expertise, and resources. These costs are meant to cover various services such as court filing fees. When initiating probate, you must file a petition with the court. There are filing fees associated with this, which can vary by county. Attorney fees. Probate often requires legal guidance to navigate the court process, manage paperwork, and handle any disputes that may arise. Attorneys typically charge either an hourly rate or a percentage of the estate's value. Executor or personal representative fees. The person appointed to manage the estate might be entitled to compensation for their time and effort, depending on the state's guidelines and the terms set forth in the will. Bond fees. In some cases, the court may require the executor to post a bond as a form of insurance to protect the estate's assets. Appraisal fees. Many estates require appraisals of personal property, real estate, or valuable assets to determine their fair market value. Miscellaneous administrative costs. These include costs for publishing legal notices, mailing documents, and other administrative expenses incurred during the probate process. All these fees add up, and understanding them can help you anticipate what to expect during probate. Let's take a closer look at the various components that contribute to the cost of California probate. Court filing fees. In California, the cost to file a probate petition typically starts around $435, though this amount can vary slightly by county. Additional fees might apply for other filings, such as petitions for auxiliary probate if the deceased owned property in another state. Attorney's fees and executor or personal representative. 4% for the first $100,000, 3% for the next $100,000, 2% for the next $800,000, 1% of the next $9 million, 1.5% of 1% of the next $15 million. Amounts above $25 million are determined by the court. Additionally, the attorney and personal representative may request and be permitted by the court to receive an amount above the standard fee if extraordinary services are performed. Bond fees. Depending on the circumstances and if the will waives the requirement for a bond, the court may require a probate bond. The cost of a bond can vary, but generally represents a relatively small percentage of the state's value. It's essentially an insurance, and the premium is just not a huge expense compared to other costs. Appraisals and miscellaneous costs. If the estate includes real property, collectibles, or valuable personal property, you may need to have these items appraised. Appraisal fees can range from a few $100s to a few $1,000, depending on the number and type of assets. Additionally, there are costs for things like publishing legal notices in the local newspaper. This can add a few $100s to your total probate costs. When you add these expenses together, the total cost of probate can vary widely. For a modest estate, the overall expense might be in the low thousands, but For the more complex or larger estates, the cost can climb much higher. Several factors can influence the overall cost of probate in California. Size and complexity of the estate. Naturally, a larger estate or one with more complex assets, such as multiple properties or a business, will incur higher costs. More assets mean more paperwork, more appraisals, and potentially more disputes among heirs. State and local variations. Probate fees and requirements can differ not only by state, but also by county. Orange County, for instance, might have slightly different procedures and fee structures compared to other counties in California, whether there's a will or not. If there is a valid will in place, the probate process tends to be more straightforward, which can help keep costs down. In case of a intestate, where the person dies without a will, disputes among heirs can lead to additional legal fees and extended probate timelines. Dispute among heirs. Any disagreements among family members or creditors can complicate the process, leading to prolonged court battles, additional attorney's fees, and increased overall expenses. Small estate affidavit. California offers simplified or small estate probate procedures for estates that fall below a certain value threshold. If an estate qualifies for these procedures, the process can be much less expensive and faster, as it avoids some of the most cumbersome aspects of full probate. Let's walk through a sample scenario to illustrate these points. Imagine that your parents' estate is valued about $150,000, and most of the assets are personal belongings, bank accounts, and a modest vehicle. Because the estate is relatively small, and there is a clear will in place, you might qualify for small estate affidavit. In this case, you can hire a probate attorney. You start by filing the necessary probate documents with the Orange County Court. The filing fee might be around $435. When you hire a probate attorney, if the fee is set at around 4% of the state's value, that would be approximately $6,000. Adding in additional costs like executor fees, bond fees, and a couple of appraisal fees for personal property, you might see total probate costs ranging from $8,000 to $10,000. While this might seem like a significant expense, it's important to remember that these costs are spread out among the beneficiaries and are often necessary to ensure that the estate is handled properly and that all legal obligations are met. Moreover, careful planning and the use of simplified procedures can help keep these costs manageable. In conclusion, the cost of probate in California can vary widely depending on several factors, including the size and complexity of the estate, local fees, and whether or not the estate qualifies for simplified procedures. By understanding these costs up front, you can better prepare for what lies ahead, whether you're managing your own estate, planning, or settling the affairs of a loved one. Remember, every estate is unique. While the figures and percentages I mentioned today provide a general idea, it's crucial to consult with a probate attorney or estate planner who can give you guidance tailored to your specific situation. If you found this video helpful, please give a thumbs up and subscribe for more insights on probate, estate planning, and everything you need to know about senior living in our beautiful community. Also, feel free to leave any questions or comments down below. I'd love to hear your thoughts and help clarify any points that may be confusing. Thank you so much for watching, and remember, proper planning and professional advice can make the probate process much smoother and less costly. Stay informed, stay empowered, and I'll see you in the next video. A quick disclaimer, I'm not an attorney or a financial advisor. The information I share today is meant for educational purposes only. For personalized legal or financial advice, please consult with a professional who specializes in probate and estate planning. Take care, everyone, and have a wonderful day.